Dear students, welcome to my lecture. Today we are going to discuss about an important aspect of contract law, that is consideration. We have a general idea about what is consideration, isn't it? Yes, we have seen that consideration is something in return, or it is otherwise known as quid pro quo. That means in every contract, parties to the contract get something in return, and that can be anything. It can be cash, it can be kind, it can be a promise, but that is something which the party gets in return. That is what we call consideration. And the general rule of consideration, we know the Latin maxim is ex nudo pacto non oritur auctio. That means where there is no consideration, there is no contract. The meaning of this ex nudo pacto non oritur auctio is from a bare promise, no cause of action arises. That means in simple terms, if there is no consideration, there cannot be a valid contract. Okay. Now, let us see what are the essential elements of a valid consideration. How and when consideration becomes legal, consideration becomes valid. Okay. Let's look into those essential elements. Section 2D of Indian Contract Act defines a consideration as when at the desire of the promiser, promisee or any other person has done or abstained from doing something, does or abstains from doing something, promise to do or abstain from doing something. Such act, abstinence or promise is called consideration. Okay, this is the definition under section 2D of Indian Contract Act. Okay, so now let us look into various aspects or various essentials of a valid consideration. As the definition says, the first point is that it should move at the desire of the promiser. That means what is the consideration is something which the promiser decides, the one who initiates the contract, the one who makes the proposal will decide what he should get back. Okay, so it cannot be any other person. It cannot be a third party who is deciding what is the consideration. Always remember, it is the promiser who decides what is the consideration. Okay, first point, it must move at the desire of the promiser. Now, second point, who will give consideration? Promisee or any other person. That means, say for example, A is selling his car to B. Okay, now ideally B is supposed to give money, which is the consideration. But if B doesn't have money, B's father or mother can give money, B's friend or spouse can give money, B's bank or debtor can give money. That means any other person on behalf of the promisee can give the consideration. Okay. Now, a consideration can be something which is already done. Like A has promised to give money if B teaches his child. B taught the child and the child passed the exam. Later, now A is giving the consideration. A is giving money. Now, A has promised to give money. What for he has promised to give money? For something which B has already done. So, consideration can be something which has happened in the future. Right now, A is painting the house, B is giving money. That means something which is currently happening. Third one, A is giving money. B promises to give his car next month. That means the consideration will come in the future. The consideration can be past, present or future. Similarly, Consideration can be an action. Consideration can be a promise to do something. Consideration can also be a promise not to do something. Say for example, A is promising to B that you pay me some money. I will not cause any disturbance by my practice. Say for example, A is practicing either dance or music in his house and B gets disturbed. So A says, I will shift the place and thereby I will not disturb you. This is a promise, and this is a promise not to do something. So that promise is also a valid consideration. Consideration can be positive or negative. Is it clear? Now, consideration need not be adequate. That means what you are getting back need not be equal to the market value of whatever you give. Say for example, A is planning to sell his car to B. A's car is worth 5 lakh rupees in the market, but A can sell it for 4 lakh rupees. Since A decides what is the consideration, it need not be adequate, it need not be equal to the market price. But at the same time, it must be real and not illusory. That means if 5 lakh rupees is the market price, the consideration cannot be 10 rupees or 25 rupees, because then it is not a real consideration. Consideration must be real, but it need not be equal to the market price. It can be slightly less or more than the market price, but it must be a real price. It must be a real consideration. It cannot be an illusory consideration. Understood? Yes. Now, as we all know, consideration must be lawful. It cannot be anything illegal. Whether the action or promise or kind which you are getting back cannot be unlawful. And the last one, consideration cannot be an existing obligation. See, you will have certain obligations under law which you must do, like casting a vote is your obligation. With, going to the court if you are a witness and giving evidence is your obligation. These obligations cannot be considerations, and therefore consideration cannot be. So if a party proposes or offers something which is otherwise also his obligation, that cannot be considered as a consideration. Is it clear? So we'll go back to the definition. What it is? When at the desire of a promiser, promisee or any other person has done or abstained from doing something, does or abstains from doing something, promised to do or abstains from doing something, such act, abstinence or promise is called consideration. And in addition, consideration need not be adequate. It must be real, not illusory. It must be lawful, but it cannot be an existing obligation of the party. That's all about essentials of a valid consideration. We'll be back with another topic. Till then, bye. Thank you.